made a video there recently and published it on my YouTube channel. I'll put a link in this video if you're watching it on YouTube. I'll put it, I think it appears this side, I don't know which side it appears. I'll put a link in this video anyway, but it's to do with the Supreme Court decision in the Zalewski case. Zalewski was a gentleman who brought an unfair dismissal claim to the WRC, and between the jigs and the reels he ended up bringing a constitutional challenge to the Workplace Relations Act of 2015 and the whole system of WRC hearings and Labour Court hearings and so on, but especially the WRC hearings. And he brought a constitutional challenge on the basis that hearings were supposed to be, or law is supposed to be administered in public according to the Constitution, and it's supposed to be administered by judges and so on and so forth. However, he lost his case in the Court of Appeal, I think in the High Court, Court of Appeal, and he appealed then to the Supreme Court. The Supreme Court delivered a decision on the 6th of April 2021, and I have a video on this channel about that particular decision. The Supreme Court held that the Act itself, the underlying legislation, the Workplace Relations Act of 2015, was not unconstitutional. However, there was some aspects of the way that the WRC carried on the hearings which were actually unconstitutional, and the Supreme Court made an order to that effect. So the two big issues which arose were a blanket prohibition on hearings, WRC hearings being held in public. This was unconstitutional, and the absence of the administering of an oath before taking evidence and the possibility of punishment for giving false evidence. These things were absent from WRC hearings. These things were absent from the procedures WRC adopted, and they have been held to be unconstitutional. So the WRC must take into account, must recognise the concerns and the findings of the Supreme Court. So there is going to be changes to the way WRC procedures are implemented in future, and there will be changes in the way that WRC hearings are going to be held. Now, there may be some amending legislation needed. In fact, there will be amending legislation needed, but before that legislation comes in to force and before it's put on the statute books, two aspects of the way WRC hearings are carried on will be implemented by the WRC from the 6th of April 2021 onwards. One is that hearings will be held in public. That's all hearings involving the administration of justice will be open to the public from now on, and decisions will be published using the names of the parties, not anonymised names as has happened to date. Now, that is to do with and concerns the hearings involving the administration of justice. There is certain hearings, for example, Industrial Relations Act 1969 complaints or trade disputes. They are not necessarily do not involve the administration of justice, because they end up with legally non-binding, unenforceable recommendations. But everything else will be held in public by the WRC, and the names will be published. They will not be anonymised. The second big change will be to do with where a conflict of evidence arises. If that's the case, well then the adjudicator will have to adjourn the hearing to await the amendment of the Workplace Relations Act 2015 to empower the adjudication officer to administer an oath or affirmation. So this is to do with the giving of evidence, the giving of false evidence and so on, and the giving of evidence on oath. So that is something that's going to have to be brought about. There is amending legislation or an amendment required to the Workplace Relations Act 2015 to give the power to the adjudication officer to administer the oath. So they are the two big claims, or two big changes rather, arising from the Supreme Court decision in the Zalewski case delivered on the 6th of April 2021. Hearings will have to be in public, haven't been to date, and evidence where there's a conflict, there will be the power for an adjudicator, adjudicating officer to administer an oath, and there will have to be punishment, some form of punishment put on the statute books for a person giving false evidence. Industrial Relations Act 1969 claims, however, will be unaffected by the Supreme Court decision or any subsequent changes because these claims are non-justiciable. They are simply recommendations of the adjudication officer. They will continue to be held in private. Hope you find this video useful. As I say, you should watch it in conjunction with the other one, which I'll link up above, because it deals with the substantive decision of the Supreme Court into the challenge to the constitutionality of the whole WRC system and the Workplace Relations Act 2015. Thanks for watching.